Welcome to Law with Mr. Wallace. Today we're going to be talking about general defences and in particular intoxication. Okay, so the general defence of intoxication is one of the most important general defences that we'll learn about, and this is largely because it can affect anything and everything in terms of offences over any of the units. So whether we're looking at the fatal offences or the non-fatal offences or even the property offences, intoxication might be relevant, and how it interacts with all the different offences can get quite interesting. It's quite a sophisticated offence, but at the same time, if you get a thorough understanding of it, it's relatively straightforward to apply in most circumstances. So let's get down to it. There's 4 things that we're going to be doing today. Number 1, we're going to get an idea of the basic principles of the defence of intoxication. We're going to look at something called voluntary intoxication, something called involuntary intoxication, and then we'll see how it works in example format. So the first thing we have to say about intoxication is that it's not technically a defence. Not in the same way that, say, automatism or self-defense or something like that is. Because with those, once you've established the thing, so you've established I was in an automatic state or I was acting in self-defense, then the court tends to say, okay, fine, you're acquitted, you're not liable for the offence that you were charged with. Intoxication doesn't really work like that, though. It's closer to an argument for a lack of mens rea, because the courts are never going to say, hey, you've just downed half a litre of whiskey, you don't go to prison. That's not going to work. But it can be treated as a general defence because it applies to so many of the offences. So effectively in your written answers, you could use it in the mens rea section, or you could use it at the end in its own separate section as a defence. You're really open in how you structure it like that. I am going to talk about it as a defence, but I want you to remember that legally speaking, that's not quite true. Okay, that's not just the case at A level either. That applies up at university and everywhere. So what does intoxication refer to? Alcohol is one. Drugs are another. I have no drugs around here. I can't show them to you. Probably a good thing, really. Intoxication refers to the effects of taking alcohol or drugs. So when you're writing about this, you can start off by saying that intoxication refers to the effects of taking alcohol or drugs. Now, as we said before, intoxication is heavily influenced by policy. This was really well put in the case of DPP versus Beard. In that case, the judge pointed out that voluntary drunkenness should be considered an aggravation rather than a defence. If intoxication were considered to be a defence, then that would be a bit like saying, as I indicated earlier, the drunker you get, the better defence you have. And that's not good, because if you did, just consider the consequences. You might have 2 people who are considering an armed robbery. One of them says to the other, what if we get caught? The other one says, well, you know what? I've got a great idea. Why don't we just get really drunk and say that it was just a bit of a drunken jape? The drunker we get, the better our defence will be. Again, the courts are not going to allow that. So, let's start with the leading case. I always teach my students to have a starting point when it comes to defences. That can be really helpful. And as far as intoxication is concerned, the starting point is the case of DPP versus Majewski. And I have it on good authority that Majewski is the correct way to pronounce that. Not Majewski or Majewski or Majewski. Majewski's got a slight F in there, I believe. Anyway, I'm going to call it Majewski. As long as you can spell it, you're okay. Now, the facts of Majewski are absolutely fantastic. You can find them in lots of textbooks. I'm sure your teachers will have spoken to you about them. But the fundamental element of it is that the defendant and his friend got drunk after taking many drugs. There's a great moment if you read the judgment where the judge, who's maybe only partially familiar with talking about these kinds of things, says that Mr. Majewski obtained 400 speeds on the morning of the offence and proceeded to consume half of them. So to put that in perspective, this guy in the morning has taken roughly 200 amphetamine tablets before going out. He's then taken some more drugs to kind of suppress that a little bit, and then him and his mate have decided to go to the pub. His friend was getting kicked out of the bar. This brought about a kind of psychosis, and effectively, how would you describe this? I suppose you might say that Majewski hulked out. What you have here is a situation where when Majewski wakes up in the morning, he really has no idea of what he's done. I will not have the... Bang! He gets him again. F you, copper! And he doesn't feel that it's fair, that he ought to be sent to prison for this kind of violent rampage. Douche! Bang! That he has no awareness of, and in his mind is very different to how he would normally act. I'm just finding a sharp thing to cut you with. I'm going to cut you from ear to ear. So his view is, I was in some kind of automatic state. I should not be held responsible for my actions. But we can see the difficulty that the court has with this. The law on it had been relatively clear so far, and what the justices did in Majewski was to really summarise the law. What they've said is that a defence of intoxication will depend on really two things. Number one, whether it was voluntary or involuntary intoxication, and number two, whether it was a crime of basic intent and specific intent. Now, in terms of knowing the law, is really fundamental that you be able to describe the difference between those two sets of things. And if you're writing about this in an extended answer, no matter what flavour of intoxication applies in the scenario, you should always seek to explain it as fully as you can. So let's talk about crimes of basic intent and crimes of specific intent. As I say, this is really, really fundamental to applying intoxication in the correct way. First of all, crimes of basic intent. It's a controversial area, but as far as we're concerned, the situation is this. Any crime that could potentially be committed recklessly, so it has recklessness as part of its mens rea, is considered a crime of basic intent. So in the non-fatal offences, that would include assault, battery, section 47, section 20. In the fatal offences, that might include gross negligence manslaughter and unlawful act manslaughter, so your involuntary manslaughters. In the property offences, it gets a little narrower because many of the property offences require intention to permanently deprive or intent to make a gain or a loss. On the other hand, specific intent offences are, as you might imagine, any offence that requires intention alone as part of the mens rea. So in terms of the non-fatal offences, that is solely section 18, wounding or grievous bodily harm, because that requires intent to cause grievous bodily harm. Similarly, in the fatal offences, that includes murder, as murder involves intent to cause the death or serious injury of the victim. In the property offences, as stated, conversely with crimes of basic intent, that includes most property offences where there's intention to permanently deprive or intent to make a gain or cause a loss. Next, we need to distinguish between voluntary and involuntary intoxication. Voluntary intoxication, as you might imagine, is where a person knowingly becomes intoxicated. Usually that means by imbibing alcoholic drinks. It also might mean taking illegal drugs, or what the courts have called dangerous drugs. It might mean taking prescription drugs, but doing that in a reckless way. So maybe taking somebody else's prescription drugs to get an effect that a doctor wouldn't really recommend. Involuntary intoxication can be a little bit trickier. The most obvious example of involuntary intoxication is where somebody has their drinks spiked. So they believe they're drinking soft drinks, they're on Diet Coke or something all night, and other people are slipping alcohol into that, or other intoxicants. It could also include cases where somebody has been prescribed a drug by a doctor, takes that in the recommended way, and it has an unexpected effect upon them. The third instance where it can apply, and this is the one you have to watch out for, is where somebody takes a non-dangerous prescribed drug, that is not known to have a dangerous or reckless effect. So for instance, if I take an ibuprofen, ibuprofen is a mild painkiller. I wouldn't expect it to make me go crazy or anything, but if it had the effect of bringing on unexpected consequences, I couldn't have anticipated that, so that is involuntary intoxication. So going back to Majewski, the main principle of Majewski is really straightforward. It's also the way that intoxication is likely to appear in the majority of scenarios. The principle is that for crimes of basic intent, so that is crimes that could be committed recklessly, intoxication offers no defence whatsoever, as it's considered that becoming drunk is or intoxicated in any form is a reckless act in and of itself. Now, the law here is really, really, really strict. We can imagine a situation where somebody has gone to the pub, maybe, they've had half a glass of cider or a shandy or something like that, and somebody spiked their drink. Now, on the one hand, they have chosen to have an alcoholic drink themselves, and the court says that would be considered reckless. On the other hand, somebody else has dishonestly spiked their drink with far more potent alcohol. If that had an effect and then caused the individual to carry out a crime, I think they could reasonably argue, well, I had no idea how strong the drink was that I was having. Unfortunately, the court will not permit that as an argument. In the case of Allen, a person was convicted of a crime after arguing that he didn't realise the strength of the drink that he was consuming. This was not sufficient to escape liability. So the bottom line is, crime of basic intent, voluntary intoxication, no defence. However, what this implies, and what was stated in Majewski, is that for crimes of specific intent, so remember those are crimes that contain intention only as part of the mens rea, then intoxication can provide a defence so long as it can be shown on the evidence that the defendant did not in fact form the necessary mens rea. This goes back to what I said at the start, that it's not really defence, it's more an argument of lack of mens rea, and we see that here. The court is not going to say, you were intoxicated, therefore you have a defence. What the court will say is, yes, you were intoxicated, now, did that intoxication mean that you were unable to form the necessary mens rea? If the jury are convinced that on the facts the defendant didn't in fact form the necessary mens rea, they were so inebriated or intoxicated or unaware of what was going on, then they can be acquitted of that crime. However, the court was very keen to point out that that doesn't mean you just get acquitted and told to go on your way, you were too drunk to be held responsible. There are these things called fallback offences. So a person may not be liable for the more serious crime, but they've still been reckless, they're still voluntarily intoxicated. So that means they can be liable for a less serious backup offence. So for instance, in murder, if a person is so drunk or so high that they did not form the necessary mens rea when they killed the victim, they can't be liable for murder, but they could be liable for unlawful act manslaughter instead. Similarly, in the non-fatal offences, while a person might have been so intoxicated that they couldn't form the necessary mens rea for section 18 grievous bodily harm, that would fall back to section 20 grievous bodily harm, because the voluntary intoxication would provide the recklessness necessary for that offence. The key principle is that drunken intent is still intent. The courts are determined not to let people get away with stuff just because they're drunk. So we can see this in action by comparing two very different cases. In Attorney General for Northern Ireland versus Gallagher, we have something called the Dutch courage argument. The defendant, Gallagher, was charged with the murder of his wife. He argued that at the time he was so drunk, they'd got into an argument, he hadn't really realised what he'd doing, and in the to and fro of the argument he'd stabbed her. Unfortunately, the police, when they were searching for evidence around the crime scene, found a receipt from a shopping trip that Gallagher took shortly before the murder, and on the receipt he'd bought two things. Number one, a litre bottle of whiskey, which he'd then consumed half of, and number two, a large kitchen knife, which he'd then stabbed his wife with. So the jury, looking at this, will think, okay, fair enough, You got drunk to kind of build up the courage in order to carry out that crime. Yes, you were intoxicated, but you also knew what you were doing. Therefore, intoxication is not a defence. On the other hand, we have the case of Crown versus Sheehan and Moore. Two defendants became very drunk and were involved in an altercation with somebody on their way home. They ended up pouring petrol on the victim and setting them alight. Now, in court, they were successfully able to argue that at the time of the altercation, they were so drunk that they didn't realise and they didn't understand and appreciate the consequences of their action, and therefore they were unable to form the necessary mens rea for murder. So in that case, it rolled back to unlawful act manslaughter, and they were convicted of manslaughter instead. Now we come to involuntary intoxication. Involuntary intoxication is best dealt with using the leading case of Kingston. Kingston is one of the saddest cases I have come across. It is unredeemingly awful for everybody involved. The facts of the case are as follows. Kingston was a businessman. A business rival of his came into the knowledge that Kingston was sexually attracted to young adolescent boys. Now, Kingston has spent the vast majority of his life aware of this attraction that he had, and he'd gone to great lengths not to indulge it. He understood that it was wrong. He understood that essentially being a paedophile, that was a morally repugnant thing. So he didn't put himself in a position where he would be tempted. The business rival had no such scruples. So they arranged for Kingston to go and talk to a third party. They then drugged a 15-year-old boy and left him in this flat where Kingston went to have coffee. Kingston successfully argued that his coffee was drugged, and under the effects of the drug he was invited to sexually abuse the victim, which he did, and while doing so was photographed and videoed, and that was used for blackmail. Now, in court, Kingston argued that he had become intoxicated involuntarily, and it was the intoxication that caused him to carry out the offences. The principle of the case is that in instances of involuntary intoxication, it can provide a complete defence, both to crimes of basic intent and to crimes of specific intent as well. However, the question for the jury remains, at the time of the offence, did the defendant form the necessary mens rea? Remember, that was the point right at the start. This is not a defence, strictly speaking. It's about whether the defendant actually formed the mens rea. In the case of Kingston, they believed that he did. They believed that while the drugs that he'd been given had lowered his inhibitions, they had lowered his powers of self-control, he nevertheless understood what he was doing at the time. And so while it's true that he probably wouldn't have done it if he hadn't been intoxicated, at the time of the offence he formed the necessary mens rea, and therefore, despite being involuntarily intoxicated, he was found guilty. Now finally we come to the interesting case of self-induced automatism, and in a way we've already covered this, but it's worth looking at again. The leading case here is Hardy. Now Hardy was round at his girlfriend's house, and for one reason or another he took some of his girlfriend's Valium. Valium is a mood stabiliser, it's a depressant, so he took that on the understanding that it would calm him down, and in the vast majority of people that is what would have happened. Unfortunately for Hardy, it had quite a different effect, and it caused him to go into a very aggressive, distracted, automated state where he ended up setting fire to the flat. His argument was that although he had taken the Valium that had caused the state that he'd gone into and caused him to carry out the criminal acts, he shouldn't be held responsible for that. The court agreed because they drew a distinction between dangerous drugs and non-dangerous drugs, and they viewed that Valium by itself was a non-dangerous drug, similar to, say, paracetamol or ibuprofen, where a person might take this and they're not being reckless about what might happen. Whereas on the other hand, for a dangerous drug like LSD, for instance, if you took LSD, you could not predict how that might affect on you, and it's well known that it has very pronounced, very dangerous effects on people, so that would be considered reckless. Okay, let's do our intoxication decision tree, or a flowchart, or whatever you want to call it. The first thing we're going to do is identify intoxication as our possible defence, and we're going to go to the leading case of Majewski. Now, Majewski is going to ask us, first of all, whether we're talking about voluntary or involuntary intoxication. Now, if we're talking about voluntary intoxication, then let's get this down here, involuntary. If we're talking about voluntary intoxication, then we've got to make another distinction. We have to make a distinction between, on the one hand, crimes of basic intent, and on the other hand, crimes of specific intent. Now, the easiest and frankly most likely outcome here is that as a crime of basic intent, we reach the end of the road and we say no defence. Now, if it is a crime of specific intent, then we get a little bit of a more interesting choice, because we have to ask, did the defendant form the mens rea? Now, if the answer is yes, they did, then they're going to be liable, so it's no defence. So, for instance, this would be the sort of case where you get Attorney General for Northern Ireland versus Gallagher. On the other hand, they might say, well, actually, no, we don't think they did form the necessary mens rea. Then there's another question. Is there a fallback offence? If there is a fallback offence, yes, then they're liable for that offence, the fallback offence. If the answer is no, then they're simply acquitted and you have a defence. Going up to involuntary intoxication, we have the same rule that applies to both basic and specific intent crimes, and that is the following question: did the defendant form the mens rea? If the answer is yes, no defence. If the answer is no, then they are acquitted. It is that simple. It doesn't look it, but it is. Right, let's have a go at putting what we've been talking about into action with an example, and we're going to use a real case here. This is the case of Lippmann. I'll go through the facts and then I want you to pause it, have a go at figuring it out yourself, and hopefully everybody will reach the same conclusion. So the facts of Lippmann make it a really interesting and very unusual case. The defendant and his girlfriend had been taking LSD, which is a hallucinogenic drug which alters people's perceptions of reality. So they'd both enjoyed being on the drug and they went to bed. During the night, Lippmann woke up and apparently, still tripping because of the LSD, was convinced that his sleeping girlfriend next to him was in fact a giant snake from the centre of the earth and was trying to kill him. And so, understandably, feeling the need to protect himself, grabbed the nearest thing to hand, which was the duvet, and started to shove it down what he believed to be the snake's mouth. in total he shoved 8 inches of duvet into his girlfriend, his now waking and panicking girlfriend's mouth, suffocating and killing her. He was charged with murder. What do you think? Pause now. Okay, hopefully you did pause and do that. If you didn't, do it now. Right. Hopefully you established that it was a case of voluntary intoxication, therefore we're going to apply Majewski all the way down. Murder is a crime of specific intent. So now we have to think, did the defendant form the necessary mens rea at the time? I think it's fairly convincing that when he was carrying out the murder, he didn't understand what he was doing and he wasn't trying to harm his girlfriend. Therefore, he will be acquitted of murder, and that is in fact what happened. However, murder has a fallback offence, involuntary manslaughter, specifically unlawful act manslaughter. Therefore, rightly, you should have found that Lippman was ultimately found liable for unlawful act manslaughter. Okay, that has been the defence of intoxication. We've gone through it fairly quickly. Please do extra reading on this and make sure to practice writing it out. Goodbye from me. I'll see you next time.